Now, I heard you say you've been with APD for 29 years.
Correct.
Have you been a police officer any longer than that, or did you start your career at APD?
I started my career with the Atlanta Police Department.
Have you seen some of the video from the footage of this interaction with Mr. Brooks?
Yes, I did.
And putting aside for a moment how Mr. Rolfe handled Mr. Brooks, in your long and decorated experience as an officer, can you tell me what you would have done differently to handle Mr. Brooks so as to decrease the possibility or the probability of resorting to deadly force?
Well, it's always easy. First off, it's always easy to Monday morning quarterback because I was not in that situation. But initially, when it occurred, I believe that I would have tried to walk Mr. Brooks back to the vehicle, closer to the vehicle. So if he did try to run or fight, I would have been able to use the car as some type of barrier where I could have pushed him into the car instead of being in a wide open parking lot.
Anything else that you observed from watching the video?
As far as what I would have done differently,
Yes.
um, no, because I believe the officers acted accordingly. The officers were trying to show compassion. They were not overly aggressive. They tried to do everything they could to um, calm the situation down. So I don't think it's anything other than that I would have done initially when it started.
Chief, I heard you say a moment ago that the only criticism you had of Officer Rolfe was that the interactions with Mr. Brooks should have taken place closer to a patrol car.
That to me, that was not a criticism. I was asked what I may have done differently, but that by no means was that a criticism.
And that's the only thing you would have done differently on June 12th?
Yes.
That's all the questions I have.
Putting aside for a moment how Mr. Rolfe handled Mr. Brooks, can you tell me, in your experience as an officer, how you would have handled Mr. Brooks differently had you been the responding officer that evening?
In regards to Mr. Brooks, well, you got to understand, I patrolled a while back. Um, and due to the situation with the college students, in my opinion, a lot of officers were somewhat apprehensive um, and feel like they may have been too aggressive. Um, but I think on the onset, they were very courteous and professional. They explained themselves. Things went far left when they tried to handcuff him. Prior to the attempt to handcuff him, everything was perfect. It was peaceful, it was cordial, it was professional. um, I don't want to really armchair quarterback people in regards to their fighting skills, or I mean it was definitely a physical assault on the officers, and they attempted to use the taser, which is less lethal. I don't know what else I would have done.
So let me call your attention to the notice of proposed adverse action. And the documents, you said that you signed that document, correct?
Correct.
And you didn't scratch out Erica Shields' name, you just signed next to hers, right?
Correct. I signed my name. I didn't scratch anything out.
So nothing prevented you from doing that, right?
No.
Okay, so if I was a private citizen and I were to do an open records request for that document, unless I knew what your signature looked like and what Erica Shields' signature looked like, I would think Erica Shields terminated Garrett Rolfe, right?
Yes.
Your printed name does not appear anywhere on the notice of proposed adverse action or the notice of final adverse action, correct?
And recalling how it looked, I don't believe my name was printed on the document, no.
So let's pull up the disciplinary process. It's A5, it's been stipulated to, and it's page 26. There is a time between the notice of proposed adverse action and the notice of final adverse action, correct?
Typically, there is a time, yes.
And that time is in order to give the employee an opportunity to review the investigative file and obtain legal or other representation. Do you recognize that from the policy? And I'll pull it up for you. It's 4.8.2, subsection D, page 26.
Yes, I see it.
So the purpose of the employee response session is to give the employee an opportunity to prepare to have a statement and a meeting with the chief so they can respond to the proposed adverse action, correct?
Typically, that is what happens, yes.
Well, it's not just typically, that's the reason for it, is to give the employee an opportunity to prepare, correct?
Yes, unless there is something that is very egregious, then I believe the chief has the right to immediately terminate someone. But typically, that is the process, the procedure that occurs.
You believe the chief has the right to do that, but you can't cite me to a policy or an ordinance that authorizes that, can you?
No, I cannot, no.
So let's go back to the disciplinary policy, same page 26. 4.8.3.2b. The purpose of the employee response session is to afford the employee the opportunity to answer the questions the disciplinary authority might have, correct?
Yes.
Now, you read 4.2.50 and the standard on use of force, and it references Graham versus Connor, does it not?
Yeah, I don't see it right in front of me, but from my recollection, yes.
And part of the tenet of Graham versus Connor, with a 29-year experience, you understand that the court specifically prohibits the use of hindsight in the evaluation of someone's use of force, correct?
No, I won't quote, but yeah, that may be correct.
Okay, let's look at the disciplinary policy again, the process 4.9.2 on page 30, the notice of emergency disciplinary action. So basically, what you're saying is you signed this document. Do you take ownership of any deficiencies in this procedure in the termination of Officer Rolfe?
What do you mean? Do I take any deficiencies?
If there are deficiencies in this process, since you signed the document, is that on you or is that on former Chief Shields?
Former Chief Shields was still the chief when that document was signed.
So former Chief Shields bore the ultimate responsibility to make sure all of the ordinances, policies, procedures, rules, and regulations of the city of Atlanta were complied with prior to the termination of Officer Garrett Rolfe, correct?
Yes, at that point, I was the only person on the police department that can fire or terminate an employee is the chief. I was the assistant chief, so I did not have the authority to terminate any employee.
Okay, let's go to page 30 of 48, 4.9.2, notice of emergency disciplinary action. So you mentioned in extreme circumstances, there is a little bit of a change in the procedure. Would you agree?
Yes.
And 4.9.2. It states the chief of police or their designee will not may, will ensure that a completed notice of proposed adverse action is issued to the employee in person or by certified mail. Did I read that accurately?
Yes, you did.
So based on your previous testimony, it was Chief Shields' obligation to make sure that Officer Rolfe received a copy of the notice proposed adverse action in person or by certified mail, correct?
Correct. According to the document, correct.
Now then we look at number 2. There should be at least 5 working days between the date of the notice of proposed adverse action was issued and the date scheduled for the employee response session, correct?
Correct. That's what's stated on the document, correct.
Because if we're gonna give an employee, and they have a right under the ordinances to give an employee response session, they have to have an opportunity to appear and they have to have an opportunity to prepare, correct? We've already established that.
Correct.
Well, June 13th, 2020 was a Saturday, right? Right?
I'm not sure what day it was.
Okay, well, you can take my word for it. It was a Saturday. And you said that everybody was in meetings, right?
We were in various meetings that day, in and out of meetings, correct.
A lot going on, right?
Definitely.
So did somebody tell you the chief was too busy to put her signature on a piece of paper and meet with Officer Rolfe?
Did someone tell me that? Chief and I were in the room and I was asked to sign that document.
Garrett Rolfe wasn't in the room though, was he?
No, he was not.
So 5 working days meant you were required to give Rolfe until Friday, June 19th to have his employee response session, right?
Yes,
And 5 days to prepare as opposed to, let's say, an hour with no preparation, correct?
it states 5 days.
And if you don't have an opportunity to respond, then the policy has been breached, correct?
That would be your argument. Yes,
Well, if you were subject to termination and you got a notice of proposed adverse action and you know you could give an employee response, you'd expect to have at least a little bit of time to prepare, wouldn't you?
yes, I would.
And an opportunity to get there.
Correct.
So minimum of 5 days per the ordinance, and that's ordinance 114-532. Are you familiar with that ordinance by number? And if you're not, I'm not trying to sharpshoot you. I was just wondering if you're familiar with it.
No, I'm not familiar with it by number, no.
Okay, so let's go to Exhibit A2, the notice of proposed adverse action. So was this an emergency action?
Yeah, I believe it was an emergency action, yes.
Do you know who made the determination that this was an emergency action?
Chief Shields did.
So again, Chief Shields is responsible for making sure that we meet all those requirements, correct?
Yes,
Now, in the upper right corner of the notice of proposed adverse action, this has been stipulated to emergency action is checked yes, and emergency action is checked no. Did I read that accurately?
that's what's on the document, correct.
And I'm not trying to sharpshoot you. I pulled that up because you said you basically were trying to recall it. Did you recall that it said it was an emergency action and was not an emergency action at the same time?
No, I didn't recall both of the boxes being checked, no.
That's not appropriate, is it?
That's not normally how it's done.
Well, it's an either or. Yes or no are usually 2 mutually exclusive options, right?
That's not normally how it's done.
So if it's not an emergency action, he actually was supposed to get 10 days to respond prior to the notice of final adverse action. Isn't that correct?
Yes,
And that's pursuant to ordinance 114-530.
correct.
And 10 days would have been Friday, June 26th, because it's 10 working days, correct?
Yes,
Yet somebody filled in, if we can scroll down, somebody filled in the time for him to respond. Now, this was created on June 13th, 2020, correct?
yes, it was June 13th.
So somebody filled in the time for his employee response, the deadline, if you will, of June 13th, 2020 at 4:45 p.m.
Yes,
And again, it says Chief Shields, but we would have no way of knowing that was your signature unless somebody told us, right?
well, I think it's readable, but yes, yeah.
Well, mine's not readable either, so don't feel bad. I can't read it. So then it says employee did not attend, and there's a witness signature there, correct?
Yes.
Now, you weren't there when that was signed, were you?
No, I'm not sure whose signature that is.
Well, whoever it is signed it June 11th, 2020, correct?
That's what's on the document, correct?
Well, it clearly wasn't witnessed June 11th of 2020 because that's the day before all of this occurred, correct?
Yes.
So for all practical purposes, there's no witness signature on that. It's invalid, isn't it?
There is a signature on there, but for whatever reason, they put the wrong date.
Well, it's important that documents are filled out properly in the City of Atlanta Police Department, correct?
Oh, definitely, yes.
Now, you have police recruits and FTOs.
Yes, we have recruits and field training officers. Yes, we do.
And you have a standard for how many typos can be on a report by a recruit before a field training officer makes him rewrite it, right?
Yes.
Was anybody watching over Chief Shields to make sure that all of these typos didn't appear, like wrong dates and emergency action, yes or no? Yes and no?
Was anyone watching over her? I'm not familiar with that anyone was watching over her, no.
Well, she's the chief. I mean, you shouldn't have to, right?
Correct.
So when we go to the body of this document, and if you can scroll up a little bit, Kayla. If this was an emergency action, there's supposed to be documentation of the reason for the emergency action, correct?
Sometimes, yes, there is writing or documentation in that narrative box, yes.
Well, are you familiar with Ordinance 114-532, Section B, that says, shall give the employee against whom the emergency action is taken a notice of emergency action in writing not later than 5 days after the date of the emergency action?
I'm not familiar with that ordinance specifically, no, I am not.
But you would expect Chief Shields to be familiar with it, correct?
Yes.
And Section 98-28 of the ordinances requires the police chief to follow ordinances, policies, procedures, rules, and regulations when taking any employment action, correct?
I can't say correct because I'm not familiar with that ordinance and I don't see it on the screen.
And that ordinance, why don't we pull up 114-532, Section B? It states the notice of emergency action shall, again, not may, shall include a statement of the emergency action that caused the action to be taken, correct? We're going to blow it up there so we can both read it. Second sentence. The notice of emergency action shall include a statement of the emergency situation that caused the action to be taken. Did I read that accurately?
Yes, you did.
To be taken is future tense, correct?
Yes.
So you can't fire somebody and 5 days later send them a notice and say, hey, we fired you under an emergency situation, so here's your notice. That does not contemplate it in the ordinance, is it?
It didn't appear to be.
And in this case, the action was a termination, correct?
For this, yes, that was a termination.
So while you have Rolfe on Fury leave, he's allowed to be outside the city, correct?
Yes.
And nothing prevented you or the chief from having the notice of proposed adverse action personally delivered to him, did it?
No.
And that's been done before with the City of Atlanta with either sensitive documents or OPS-based stuff. They drive it out to the officer, don't they?
Yes.
You agree that the mayor had no authority to fire Garrett Rolfe, right?
I won't say the mayor did not have authority. Typically, the police chief makes that decision, but I won't say the mayor does not have authority.
We'll have to just defer to the lawyers on that. Fair statement?
Definitely.
Okay. Let's go to the disciplinary process, 5.26, page 46 of 48. It's A5. You're familiar with a priority 1 complaint?
Yes.
And that's an allegation of a major nature within the city of Atlanta, an allegation of misconduct of a major nature. Fair statement?
Yes.
And that's a complaint is of a serious nature, or the complaint alleges the employee's conduct caused or resulted in serious injury. The complaint alleges that unauthorized force was used and there's evidence of serious injury. Did I read that accurately?
I believe you did, but nothing is on the screen.
Okay, well, technology is awesome when it works. Bear with us a second. You're familiar with a priority 1 complaint is required to be investigated by OPS, right?
Yes.
Let's move on to the conducted energy weapon policy stipulated admissibility at A6. And you would agree that the allegations made in this case clearly outline a priority 1 complaint?
Yes.
Are you familiar that the conducted energy weapon policy states OPS shall investigate suspected work rule violations arising out of an employee's use of a CEW?
Yes.
And it actually references the disciplinary policy, does it not?
Yes, it does.
And that's at 3.7, if you can just pull that up, Kayla. Okay, well, I'll just note for the board has that, it's 3.7. Let's go to the use of force policy, which has been stipulated at 3.6. OPS will investigate suspected work rule violations arising out of an employee's use of force in accordance with APD disciplinary process. You're familiar with that, correct?
Yes, I am.
And the work rules policy, which has been stipulated, all violations of work rules shall be investigated fairly, uniformly, and equitably, correct?
Correct.
Okay, let's go down to the use of force policy here to 3.6. And just for the board's benefit, I apologize, we're having a little bit of a lag. So there it is, 3.6. The Office of Professional Standards will investigate suspected employee work violations arising out of an employee's use of force in accordance with the disciplinary policy, correct?
Correct.
Now, OPS never interviewed Officer Rolfe about this case, did they?
I am not familiar with if they did or did not.
Well, you agree, based on what we've gone through, 4 separate policies in the city of Atlanta require OPS to do an investigation of a priority 1 complaint, such as it's outlined in the notice of proposed adverse action, correct?
Yes.
And you never met with Officer Rolfe for his employee session, correct?
No, I did not.
Do you agree with Chief Shields' statement to the AJC on January 7th, 2021, that it's unfair to judge an officer from a snippet of video?
Oh, yes, I agree with that.
And that's why we have OPS do in-depth investigations, including statements from the officers, correct?
Correct.